Thank you so much. We are so happy to see everybody here. DA Krasner, thank you for bearing with us and figuring out the technical glitch. My name is Alyssa Haydari. I am the Deputy Director of the Institute for Innovation in Prosecution. Thank you everyone for joining today's virtual panel discussion on probation, parole, and prosecution. We recognize that some components of community supervision are completely unknown to many people, and that includes prosecutors. And I include myself in that group as a former Manhattan ADA. So this panel is going to provide a basic overview of parole and probation, as well as the distinctions between the two types of community supervision. Today's panelists are also going to look at how community supervision and prosecution intersect. We have several highly distinguished panelists with us today. I'm going to very briefly introduce them. First, we have Professor Fiona Doherty. She is the Clinical Professor of Law and Director of the Jerome and Frank Legal Services Organization at Yale Law School. Thank you so much for joining us. We also have Eric Gonzalez, the District Attorney from Brooklyn, New York. Larry Krasner, District Attorney from Philadelphia, Pennsylvania. Patrick Rodriguez. Mr. Rodriguez is the co-executive director of the Georgia Coalition for Higher Education in Prisons, an organization dedicated to developing high quality higher education in prisons. And we also finally have Vincent Schiraldi, who's an adjunct professor at the Columbia School of Social Work and senior fellow at the Columbia Justice Lab. Typically, I will moderate these conversations, but we thought we'd change things up a little bit here at the IIP and have somebody else moderate for us. And so we are so lucky to have Michael Jacobson in that role. He is the director of the CUNY Institute for State and Local Governance. So thank you everybody for being here today, taking time out of your busy schedules to talk about this very important topic. And at this time, I'm going to turn things over to Michael Jacobson. Thanks so much.
Thanks, Alyssa, and hi everyone, both in the audience and obviously to the panelists. So the sort of structure of this discussion is that we'll spend a little bit of time on the understanding the sort of basics, setting the groundwork and context for community supervision, sort of move to a discussion about how community supervision, probation, and parole interact directly with prosecutors' offices and how they think practically and conceptually about community supervision, and finally the impact of community supervision, both on the folks who are supervised and then in the aggregate in terms of outcomes. All that will have to happen in about 40 minutes, and then we'll have 10 minutes at the end for questions and answers. So to all the panelists, I'll start out by asking you questions if you could answer as succinctly as possible, since we're short of time. And if I apologize in advance if I interrupt, just to sort of move the conversation along. But why don't we start out with Professor Doherty for some sort of big context setting, and maybe you can talk for a couple of minutes just about what is community supervision, sort of broadly, conceptually, the sort of differences between probation and parole, the two most common forms of community supervision, and then maybe a little bit just on the folks who, the probation officers and parole officers who do that work, what their responsibilities are. So I'll turn it over to you for the first couple of minutes.
Okay, thank you, Michael, and it's a pleasure to be on this panel. And as Michael said, being on community supervision typically means being on probation or parole. So you're under formal correctional control, but you're not inside a prison, you're in, or a jail, you're in the community, as long as you abide by the conditions set for your release into the community. And about 7 in 10 people who are under correctional control are on either probation or parole, just under 4 million. While about 3 in 10, about 1.7 million are in the prison or jail. So what is parole? So parole typically means that you are released early from a prison sentence, which is set by a judge. And you're supervised in the community for the balance of that sentence. So if someone got a 5-year sentence, a parole board could decide to release them, say at year 3, and then the person would be in the community for the balance, so for 2 years. And the parole board would decide what conditions the person had to meet while they were in the community. and the person would be released to the supervision of a parole officer. And typically parole officers have a lot of discretion in how to decide how tightly to enforce conditions. So that's parole. Quickly, probation. In its traditional form, probation was an alternative to prison. So a judge would sentence someone to probation either as the sentence for the crime or as a way to avoid sentencing someone for a crime. The person stays in the community and does not risk going to prison unless a probation officer who supervises them while they're on probation says that they have violated a condition and the judge agrees. So I said probation was typically an alternative. Now it's often a supplement. So a lot of times now people get split sentences. They go to prison for a while, and then they have what's called a tail of probation. And maybe I'll just say something quickly about the conditions of probation, because the conditions of probation and parole tend to look very similar. Things like no new crimes, report as directed to your probation officer, answer questions by your probation or parole officer truthfully, drug testing, no alcohol or drugs, you have to work, you have to support your dependents, etc. So why don't I leave it there?
Great, thank you so much for that. So it probably makes sense to turn this over to Patrick Rodriguez for a minute. You have a valuable perspective here and lived experience. We heard Professor Doherty talk about the sort of purposes of parole and probation and what they're designed to do. You have some lived experience with this, so it'd be great to get your perspective on both the experience of someone who has been under supervision, the process of being supervised, and any sort of mismatch between that you may or may not think about between the conditions that are set and the actual experience and purpose of being under supervision.
Yeah, thank you so much for that, Michael. My name is Patrick Rodriguez, and I was actually released from prison in December of 2019, so 29 months ago, and I am the co-executive director of the Georgia Coalition for Higher Education in Prison, and most recently been named the director at the National Executive Council at Columbia University, where we are actively working to address historical systems of oppression by bringing the issues of poverty, under-resourced education, and community empowerment into proximity with state agencies, policymakers, and community leaders alike to reimagine and reshape the future of this nation. It's important for me to note that I am currently on parole, along with 180,000 other people in Georgia, as we lead the nation and world in community supervision. I do not say that to bash Georgia. I say that because I love Georgia, and this is my home. As someone who has been living here for almost 20 years, I have lived in both rural and urban communities. I have been through multiple local jails and state prisons. I have seen so many different things. I have seen Georgia grow tremendously in positive ways. I have seen us win the World Series and become national college football champions all in the same years. Go Braves, go Georgia. And after my intersection with the prison system, I saw something else that has stayed at the top of mind for me. And that is the prison system and community supervision. And that is the way that is being addressed. I have not seen a dramatic reduction in incarceration rates, and I have not seen a dramatic reduction in supervision numbers. Yet I do not think that we do not have the potential to have the lowest of both of these in the nation. As someone who has been to prison and who is on parole, I find myself engaging in these conversations more so that it can be a place of intellectual banter that hopefully leads to learning from one another, as I am very excited to be in community with both Brooklyn and Philadelphia, the district attorneys that sit here on this panel today. These are complex issues, both in theory and practice. And as we think of what justice is and how that is served in this nation. To answer your question, probation and parole, it's like, so my question was actually kind of answered by Fiona earlier, but essentially, parole carries on. So like when you're in prison, you receive a risk score here in Georgia specifically, right? Your risk score is coupled along with your final disposition. So your disposition with the amount of time that you have spent come together to create a number of months that you serve. Once you get to that number, you then come up for parole. After you come up for parole, then it is decided by the parole board if you're allowed to continue your correctional control on the outside and in essence be free, right? And I say in essence because of all of the policies that currently exist for people who are currently on probation and parole that make it actually difficult, sometimes even more difficult than surviving in the prison system in the free world. So yes, it is a good thing to be released, but actually sometimes it's actually a detriment to some individuals as they just continue in a circular motion and go back into prison because they're not able to I guess, be seen as be seen as equal as everybody else, right? And so these conditions are assigned in various ways. I think that it's based on the type of crime that you commit. It's based on the location that you commit. It's based on your parole officer. And there's no real standardized way to actually do what is known as a risk assessment. And this risk assessment determines the conditions that are put on you. Personally, I am on call-in probation. I don't have many conditions put on me except to call in once a month and to pay a 32. I think it's like, I actually pay extra every month. I'm supposed to pay like 30, but I pay 36 for good luck, just to give a little bit extra to the state to hopefully they don't mess with me or anything like that. But so as somebody that's on parole, it's like I've done all of these like really great things, right? I'm making advances. I'm in community and conversations, intellectually thinking about these things. But at what point am I quote unquote rehabilitated? At what point is my case looked at by the state, and the state is actively pursuing that and saying, hey, we actually need to give this person another opportunity. We know who they are, we know the work that they're doing, and we actually think that they should be released from correctional control so that they're not withheld, but they can reach their potential. And I think that that's the missing part there when we think about probation and parole. I could go on for maybe the rest of the entire time, but I don't want to take up too much because we're a little bit short. But thank you so much again for having me on this panel with everybody.
Thank you for that, Patrick. And I want to bring the DAs into this, and I do think it's important to just take a moment and talk just for a second about you raised the issue of Georgia and how many people are under community supervision in Georgia. We had in the United States, I mean, people are much more familiar with this term, sort of mass incarceration and what that means. I think Vinny and I talk about this a lot. We also have mass supervision in the United States. When you look at comparing us to other countries around the world, we have hugely high percentages of our population who are under some kind of community supervision, far more than any other country in the world. And Georgia, as you said, Georgia actually leads the United States. Leads might not be the best word here in the proportion of its folks who are under that control. So I want to bring DAs in, and maybe I'll start with DA Krasner, because given what everyone said, given the huge numbers of people that are under community supervision, what winds up happening in the United States is a very high percentage of those folks wind up going back to prison. Either because they've violated the conditions of their supervision, so they haven't committed a crime, right? It's what's called a technical violation. So you violated one of the conditions of your, let's just talk about probation, but it could easily be parole. You have to report, you can't take drugs, you have to have a job. You could have violated those conditions and be sent back to prison, or you could have committed a new crime, or even just been arrested for a new crime and also be sent back. So I want to start with DA Krasner, and then I'll get to DA Gonzalez about how you think about the distinction between sort of technicals, pure technicals, as we call them, and new crimes, but the whole issue of violations of probation and parole and returning to prison. How does your office sort of not just think about that, but what are the policies around those issues?
So thank you for the question. Please feel free to call me Larry. It's great to be on this panel.
Yeah.
Technical violations are obviously, in general, categorically a lot less serious than new crimes. Needless to say, not all crimes are the same and not all technical violations are the same, but as a category, they're far less serious. Ultimately what you're trying to do with supervision, among other things, but probably most importantly, is not have a person commit more crimes. So when someone actually goes out, they're on supervision for a bank robbery and they commit another bank robbery, that's a bad thing. And it is a bad thing that I think most prosecutors would say is deserving of serious consequences, which may well include additional incarceration. When someone doesn't pay their supervision fee for the honor of being supervised because they're broke, those are the kinds of situations where there really should be no consequence. And then there are other situations where some consequence is appropriate, but shouldn't be much. I think the most infamous Philadelphia example of a technical violation gone rogue was when a prominent Philadelphian, known to many of you as Meek Mill, popped a wheelie on a motorcycle, which is not actually a crime. And the judge, who had been supervising him for nearly a decade, periodically making the supervision longer and longer, as in her mind, he committed more technical violations. She ended up giving him 2 years in jail for that, which was more time than his original sentence for a drug case. That was overturned, and it was overturned with support of my office. But it really does get that stupid. Sometimes the way technical violations have been handled is they're almost viewed as rebellious teenagers doing something their parents don't like. And the consequence is completely disproportionately large to the activity itself. What policies do we have? Well, I can tell you the short version of our policies is that in the last term, I've now been in for a little over 4 years, before the pandemic hit and made everybody's statistics look different, we cut supervision, meaning supervision on probation and parole, by about 2/3, meaning future years of supervision being generated by the Philadelphia courts during that time period as compared to prior administrations were reduced by 2/3 of it. Some of it on the sound advice of one Vinny Schiraldi, and some of it on the sound advice of one Eric Gonzalez. If I only could have reached out to the rest of you, I would have gotten your sound advice too. So, what you do is you can come up with caps for what is the most extreme consequence, or at least a presumptive cap for the consequence that would flow from a technical. You can come up with caps for how much supervision is appropriate in light of the science. And I'm sure Vinny and others will give you more inside track on the science.
Thanks. Before we ask Vinny to do that, maybe since you opened the door, Larry, to calling you by your first name, I'll take a liberty and call you Eric, although Vinny makes me call him Commissioner Schiraldi, but for everyone else, I'll. So can you also give us your perspective, both that Larry just did on this sort of distinction between technicals and new crimes and how your office thinks about that, but also any changes you've seen or implemented in the last few years on those issues while you've been the DA?
It's great to be here with everyone. And Mike, I think, as part of my taking over of the Brooklyn District Attorney's Office, I was elected at the same time that Larry was elected. One of the things that came out of a lot of thinking with criminal justice experts, and Vinny was on it, and Mike, you were on it, and others were on it, was how do we address this issue of mass supervision? And so, one of the things that we thought would be important for success and actually for improving public safety is to simply reduce the footprint of supervision in this county. We had, as a policy, this office, prior to 2019, required every case where there was a plea or a sentence, the maximum period of parole and the maximum period of probation. And so, like Larry said, those things tended to get extended as people came in and out of the system for more technical violations. And so what we saw was a real circle of people being reincarcerated on things that did not really directly relate to the public safety, and really undermine community trust in the criminal legal system here in New York City. So the thought was, let's give our ADAs discretion, but let's start with the default position that when we negotiate a plea, that we're being upfront with the court, with the defendant, and very importantly, with victims of crime, by saying we expect that at this earliest stage, the person will be released back into the community, put on community supervision, and for what definitive period we're talking about. And so as a policy, the office no longer asks for the maximum period. We normally ask for the minimum period, with the ability to ask for more as needed after a careful evaluation of the case. And I think, the impact of that was just people were more successful during their time on parole or on probation. They were on it for a shorter period of time. And sort of the tripwires that Larry was talking about that caused people to get reincarcerated, they just weren't there that long, right? They were able to successfully, navigate, difficult circumstances. And then the piece of that I said to the community in Brooklyn, and I think, part of the conversation is just kind of what we want to do with supervision. And so for my office, it meant more reentry work and building life skills and job training and other things to make people successful as they were reintegrated back into their communities. And so it's philosophical, but it's also very pragmatic when it comes to trying to keep people from reoffending and getting reincarcerated.
Thank you, Eric. So let me bring you in here, Vinny, and maybe ask you to address two specific points that I know you've thought a lot and worked a lot on. One is this issue of there are so many people, as we all know, on probation and parole, almost 4 million, and a huge number of them wind up back in prison through either technical or new violations. So maybe you could talk for a minute about this notion that one of the drivers of mass incarceration actually is the probation and parole system. And then secondly, one of the things that we haven't touched on yet is, like the racial disparities that we all sort of know about in mass incarceration, overwhelmingly people of color, overwhelmingly people from poor communities. The same is true in probation and parole. So maybe you can talk for a minute about how those systems either further exacerbate racial inequality and what maybe can be done to mitigate those differences.
Great, thanks for having me on, Mike. Yeah, a couple of thoughts about that. I mean, just to harken back to the beginning, and Fiona touched on this, and her writings really have been very instrumental in my own thinking. There's one particular article entitled "Be Good" as sort of the admonition for what you need to do when you're under probation and parole. But they started in the 1800s as a very overtly helpful project. This was a rehabilitative project meant to reduce the number of people either that were coming in the front end or get people out sooner for playing by the rules and participating in programs. You fast forward to they lasted for 100 years, at least with ostensibly the notion that rehabilitation was their major underpinning. Whether they were any good at it or not, leave that aside for a second, but there was no question that that was the goal. And then in the 70s, there was sort of the death of rehabilitation, the beginning of mass incarceration and mass supervision, and people started to frown on rehabilitation as a real goal. And so, community supervision, which renamed itself community corrections, literally like prison in the community, kind of pivoted to become a much more punitive, much more surveillance focused, much more trail them, nail them, and jail them approach. And the number of people under supervision mushroomed from about 1 million in 1980 to about 5 million before it declined. But it really stopped having any semblance of helpfulness, or at least stopped being dominated by it like it was, in its founding. But the rationale for it in litigation stayed that way. So if you look at the two leading decisions, Gagnon and Morrissey, that define why probation personnel can search somebody's house without a warrant, or why people under supervision don't have a right to counsel or a right to remain silent like the rest of us take for granted, it's because the notion was, well, this is a helpful thing. And the probation officer's like your friend. So you don't want to put the courts in between two friends that are trying to help each other. And we literally are sending more people to prison every year for technical violations, non-criminal rule violations, than the entire prison population was when Gagnon and Morrissey were decided. It's about a quarter of the people going in every year. So over $2 billion worth of expenditures. And there's no data to support the notion that imprisoning someone for a technical violation improves public safety. In New York City, you know, from Mike through to me, through to Ana Bermudez, who's the current commissioner, the number of people under supervision declined by 80%. It used to be over 80,000 people under supervision in New York. Now it's about 11,000. Nobody even noticed. There was no negative impact on public safety, and research Mike and I have done showed, in fact, public safety got, you know, improved dramatically during that time period. I'm not saying it improved because we had less probation, but certainly the vanishing of 80% of the probation caseload didn't seem to have any negative impact on public safety. Recently, I did a regression analysis with some of my colleagues looking nationwide from 1980 to 2019 at the number of people under supervision, probation, and parole, amount of crime, and the impact on incarceration. And it showed that the more people you have on probation and parole, the more people you incarcerate. So it's the opposite of an alternative to incarceration. And that parole particularly was positively associated with violent crime, meaning the more people you had on parole, the more violent crime you had, when you control for a bunch of other factors that might explain why violent crime went up. So that's about as dramatic a failure from a public policy standpoint as one could imagine. And because those are the two core purposes of probation and parole. And that's why what DA Gonzalez and DA Krasner, Larry and Eric are doing is so important, which is to really sort of scrutinize who goes on for how long and what their conditions should be. So it's not this sort of massive one-size-fits-all revocation trap.
Thanks, Vinny. And maybe just to follow that up, we can turn back to Fiona for a second, because we've been talking for a while about the sort of flow of cases from probation and parole back to prison for, largely technical violations and some new crimes. And Fiona, in your clinic, you and your students work on the revocation processes themselves and do defense work there. And it's not, this is, as we're all saying, this is not just an inside baseball sort of in the muck of the system thing. This is an incredibly important process that winds up sending hundreds of thousands back to prison for a year, that, as Larry and Eric have said, many of which are not for crimes at all. Can you talk for a minute about what that revocation process is like, and maybe a bit on the difference between a purely technical revocation process and one that's based on the allegation of a new crime?
Sure. So either a parole officer, if the person is on parole, or a probation officer, if the person is on probation, can initiate what's called revocation proceedings. So they tell the judge if it's probation, or the parole board if it's parole, what conditions the person is said to have violated. And it could be a criminal violation and an allegation that there was a new crime, or it could be a technical violation, or it could be both. You might have a petition that includes both technical and criminal. One important difference is that if someone's on parole, it's generally really hard to get them out. They're generally detained in prison while the revocation proceedings are going on, and that can take months. Probation, you've got a better chance as a lawyer of getting someone out during the pendency of the hearings. But the hearings, whether it's technical or criminal, look the same. The same standards apply, and they're really, really different than the standards apply if the person isn't on probation or parole. There is no right to a jury trial. The standard of proof is a preponderance of the evidence, which is just a world away from the normal criminal standard of beyond a reasonable doubt. As Vinny said, there's no absolute right to counsel. Many parolees in particular, go unrepresented, and there's sharply reduced evidentiary protections. So the burden of proof is by a preponderance of the evidence if someone violated a condition. And you can imagine, if the condition is you were supposed to go to this treatment appointment 2 months ago on X date and you didn't go, it doesn't take much to prove that. Often just a probation or parole officer's word. So the atmosphere of these hearings is often like that you're just incredibly legally vulnerable, and you're really throwing yourself on the mercy of the parole board or the judge not to revoke and not to send you to prison. One really important dimension of this is that if someone is accused of a criminal violation, now the standard of proving that crime is preponderance of the evidence, not beyond a reasonable doubt. But even more important inside those hearings is if you also missed a treatment appointment 3 months ago, then they can use that violation to get the outcome that they want on the criminal case. Again, this would just totally up to the prosecutor and judge's discretion. Obviously, Eric and Larry are leading the way on a very different approach to these cases, but just to emphasize how legally vulnerable you can be. Even if you're acquitted by a jury of the crime, you can still be revoked if you're on probation or parole for that crime, because the evidentiary standards are different.
Hey, Mike, I just jump in real quick. It's a little theoretical for a thing that actually touches the lives of like 4 or 5 million people at a given time. So like, just to give a few examples, like I met a guy on a panel once talking about parole in New York who did it a year because the woman he married had a felony conviction and he had a prohibition against being in association with somebody with a felony conviction. In California, a man named Kerry Lathan was picking up a donation from, I'm blanking on his name now, a famous musician and philanthropist who was a previous gang member. That guy got shot, both of them got shot, and he got revoked because he was associating with a former gang member. In Georgia, I thought that the tragic case of Rayshard Brooks, and if folks haven't seen the video of Rayshard Brooks, if you want to understand what folks feel like, take a look at the video. It's on CNN's website. He was the guy that was sleeping in the Wendy's parking lot. The police came, they asked him to pull over. He pulled over politely, answered all their questions. At some point, you see the police officer runs him. He's on probation. They start to arrest him. He flees, and in the ensuing scuffle, gets shot and killed. Now, this is at a point where there are more people on probation and parole in Georgia than live in Atlanta, and more people on probation and parole in America than live in most states. And we don't know why Rayshard Brooks ran away, but it doesn't take a big stretch to know that, you know, unlike me, who might have gotten pulled over for drunk driving, it would have been a ticket and a big hassle. He was going to do a year behind that drunk driving because he was on probation. And so folks like this, they're living on the edge, so much so that a majority of respondents in Texas who were in prison, who were asked, would you prefer a year here to 5 years on probation, said, I'd prefer a year in a Texas prison to 5 years on probation. It's that sort of tenterhooks that folks are living on that really is, I just think it's understudied and under-discussed in dialogues around mass incarceration.
Thanks, Vinny. And just one note before I turn it back to Patrick and then go back to the DAs for a second. You know, it's a pretty well-researched part of the field that tells us that for folks who do violate probation and parole, especially for new crimes, violations happen very early in the process. And, you know, the statistics are that if you make it through the first 6 to 9 months of probation or parole, your chances of violating go way down. And so there's long been a mismatch in the field about the necessity for, you know, 5-year terms of probation or parole. In Texas, it's common to have 10 or 15-year terms. When the research says, you know, if you make it through the first year and a half, you're probably the overwhelming odds are you're going to be fine. And all that happens from lengthening the amount of time you're under supervision is giving people a chance to violate you for something that, as we've all said, is not a crime in the first place. But so going to this notion of impact, especially for those under supervision, Patrick, I'm curious to hear about since you've experienced, we've mentioned Georgia now a few times, but since you've experienced Georgia supervision in the form of parole supervision, and you obviously have a very good sense of what would be necessary to help improve your or other folks' lives who are under supervision. What's the match or mismatch between what you think people could really use once they're leaving prison versus the reality of parole supervision, at least in Georgia?
Thank you so much for that. And just really quickly to touch on like Vincent's point about Rayshard Brooks, I remember that happening. But they were like, it was like what I consider assumptive policing, right? And these are practices that are still engaging that led to mass incarceration in the first place. And also we're very much living in the age of mass incarceration. I think we talk about it as if it's past tense, but it's currently current. And I think the indicator, I'm pretty sure everybody has heard the statistic, like 5% of the world's population, 25% of incarceration. That is a very large indicator that it's happening. So when we talk about the effects of mass incarceration, we have yet to realize the effects of mass incarceration because mass incarceration has not gone away, and that would be more in the future tense. So I just really want to center that as we like think about, I think when we get into these conversations, we also, we talk about the war on drugs, we talk about the 80s and the 90s, but that's still the 2000s, the 2020s, based on the things that are happening and just the numbers that currently exist. And so like when I got out of prison, I remember like I went to the probation parole office, et cetera, and I had a transfer. I was in Cobb County, and then I had to move over to DeKalb County. So I went to the office, everything pretty much within the first 6 hours of release. I just went straight there like, hey, I'm going to be studious. You know, I'm on my way. Like I'm kind of excited and nervous. I feel like I've done something wrong, but I haven't. And so like I'm going over there or whatever. And they immediately, it was again, I was back in prison. I've had to sit down. I had to wait, had to put my hands behind my back. I had to go through the metal detector. They had badges and guns, which I don't understand the badges and guns thing, but I get it at the same time. And I was like, hey, I'm actually about to transfer over to DeKalb County, and like, you know, how do I go about this process? I was really nervous. I actually had the assistant superintendent's card to call because I was nervous they're going to violate me because I was transferring. And she said, just call me if I have to, like, I'll make a call and stuff like that. So I wasn't able to like go through the process in a linear fashion, as I had to like almost have backup from the state because I felt like another agency was going to violate me within the first 24 hours. And they're like, oh, well, you're going to have to take a drug test tomorrow down at the courthouse. I said, well, why can't I just take a drug test here? Well, that's not how we do it here. I said, my friend drove me. I don't have a car. Like I could take a drug test right now. I'm 100% clean. I'm really not worried about this, et cetera. And they're like, well, no, you need to go down there. You need to pay $25 or whatever. I said, but I have my transitional center check and I don't have a bank account and I don't have $25. I mean, I could try to ask my friend for that, but that's what you're asking for is essentially impossible unless I have a connection to resources. They don't like the way I speak to them. So they just sit right there. And I was like, okay, fine, whatever. Eventually they ended up letting me transfer over and I took my drug test in DeKalb County. But right there, just from the offset, within the first 8 hours of release, I was immediately hitting tension back against to where like I was approved to transfer. I was able to take a drug test, all of those things, et cetera. And then I received the first call from my probation or parole officer and I'm on the phone with him. And he's like, hey, what's going on? I was like, hey, how are you, et cetera. We did like a little video chat. They do video chats nowadays because it's like 2021, like a video chat check-in, a Zoom or Google Meets or something like that. So it's like the future is now, right? But like when I was talking to him on the phone, I was like, well, sir, what am I supposed to do? He's like, what do you mean? I was like, well, tell me what to do and I'll do it. So well, you can live your life. I said, I haven't lived a life in almost 5 years, sir. So just tell me what to do so I can make sure that I'm in compliance and I will do it, sir. Anything that you need, sir, anytime, sir. Because I was ingrained that I could not move without the permission of the state. And that was within the first week of release. He said, hey, you can live your life as a normal person. I'm like, oh no, this is a trap. I'm not going anywhere. I'm just going straight to work, coming straight home, because I felt as if I couldn't live my life, even though that was being stated by that person, because I felt like it was a cloud that still is over me to today. And it's like, we're just waiting for you. We're in the background. We're like waiting to like creep up on you and catch you. And then we're just going to put you back in prison. Because if you've ever read, I guess it's The Apology, whenever the opening lines, he says, they indicted me on charges and I did not even recognize myself. Whenever prosecutors and district attorneys do that inside of the courtroom, they like read who you are in like the worst possible way. And I'm like, no, I'm not that person. And that's exactly how I feel like you're being looked at through the Department of Community Supervision as it relates to the person that's on the paper, because all they have in front of them are the charges that are brought forth and the descriptors that are there beside them as it relates to risk score. So if I'm a person that was sentenced on drug trafficking, possession with intent, possession with intent, simple possession, I'm not sure what my risk score would be or what my charges would say, but I am a menace to society, right? I am the person that you want to put away, quote unquote. I'm not that person. I made choices in my life and I fully accept responsibility for that. But beyond that, it's not like, let's have an intervention, not an intervention of like, hey, what is da 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 da? Hey, how's it going? How are you? Hey, are you doing okay? Are you good? Do you need access to, I got a hotline for food. I got a hotline for housing. Those things weren't said to me on the phone. It was more of like a checklist of things, which I understand the checklist of things, but there was the missingness of the humanity. And I really just want to say I am working with the Department of Community Supervision here in the state of Georgia, and we're having conversations about how to center the humanity of individuals in a little bit more of a way. But as we think about mass incarceration and being on this call with both organizations, universities, prosecutors, state agencies, nonprofits, et cetera, it's going to take, including the Department of Corrections, who is on this call right now, it's going to take all agencies and institutions coming together in order to reduce this. It's not a nonprofit org or one advocate or one DA or one state agency or DOC, et cetera. It takes everybody figuring out how to unilaterally come into position and say, this is the approach that we want to take to safety, because all of this goes back to safety. And everybody wants to be safe, no matter who you are, where you live, what race you are, what language you speak. But we need to figure out how is it that we help people who are so obviously in need of help.
Thank you. And I want to close this out by getting back to the DAs, just because, you know, in both of your jurisdictions, obviously, you've spent a lot of time thinking about these issues and acting on them. In both your jurisdictions, as you've both talked about, you've seen huge declines in the number of people under supervision, how they're treated. I'm curious to hear from both of you, at least quickly before we get to the Q&A, you know, how much of a live issue is this among prosecutors in around the country? I understand there's 3,000 or so of them, and so you're not going to speak for all of them, but it's such a huge issue that directly and indirectly obviously affects prosecution. I'm curious about the issue that the whole panel is on: probation, parole reform, the intersection with prosecutors. How is this an issue that in fact is getting picked up prosecutors around the country to do the same sorts of things you folks have done? And either one of you can start. Eric, you want to start?
I'll jump in. Larry and I belong to a group of prosecutors called Fair and Just Prosecution, and we're actively talking about these issues and trying to, you know, shine light on the issues as we see it as prosecutors, about why this system of, you know, mass supervision is dangerous and does not improve public safety. But I wanted to, you know, just thank Patrick for sharing so much. And when I, and really, you know, shining light to the humanity, his humanity, and how the system, you know, doesn't deal appropriately with people who are trying to be successful in returning home. And you know, for me, I was able to support in New York State a law that was passed this year, less is more. I think I was the first prosecutor in New York State to support it. And when I supported it, it was not very popular, you know, with other DAs in our state association. Ultimately, through advocacy and a lot of leadership from Vinny and Mike and others who really were on the issue, I believe about 8 or 9 prosecutors ultimately came around and supported less is more when Governor Hochul recently signed it. But I think it dealt directly with some of the issues Fiona talked about. You know, there was, it did a few things that were really important in creating more fairness in terms of, you know, dealing with and putting limits on, you know, technical violation and what would happen when someone is, you know, found responsible for a technical violation. There's a lot more due process put involved, given, including right to counsel, having these hearings not in correctional facilities, but out in the community, really setting these limits of what reincarceration should look like for things. And of course, which I think is one of the big pieces that Patrick is speaking about, the humanity was giving, earned time credits for people who have been successful on the outside. And so for every 30 days that someone has been successful, they had a reduction on the amount of time that they were on parole. And it could lead to literally like a parole sentence of 5 years being reduced to 2.5 to 3 years, so almost by half, reducing the amount of time people would be on post-release supervision. And again, making a carrot instead of simply a stick in the way that we were dealing with people who were on supervision. So I was happy to support that. And I think that, jumping on early on that issue and trying to encourage some of my fellow district attorneys to support this was, an important step. And I was happy to stand with the governor when she signed it into law this year.
Thanks, sir. Larry, your take on the sort of national possibilities for this sort of work?
So number one, I agree with everything Eric said. And in the interest of time, let me try to be concise. He's talking about incentive. There's sort of a bright side, and then there's a dark side, a shadowy side. The shadowy side might actually be the most important as we talk about the future of this. But, the bright side, the obvious stuff is that incentivized good behavior works better than always saying no and hitting people in the knuckles. So the incentivization of guilty pleas, where we don't have legislation, and Pennsylvania is pretty good at hate groups and not very good at good legislation, but where we don't have it, an individual prosecutor who has a lot of discretion can do things like offer guilty pleas where at the time of the plea or at the time of a sentencing after a trial, the DA is locking in that if you behave yourself for 1.5 years, we'll support your petition for early parole. We're finding that has positive outcomes. There's a massive reduction in mass incarceration that comes with reining in excessive supervision. And Georgia, I think, was leading the way there, but Pennsylvania was about second or third for quite some time. Pennsylvania's pretty damn bad at this stuff too. There is the reduction of caseloads by probation and parole officers. They really can do some good stuff, especially in the years that count, which are the first couple and maybe the third year, but they can't do it when their caseloads are twice the national norm, which is actually twice the recommended limit, which is where Philly was when I took office. That's all sort of the bright side of it, saving the resources, putting them into public education. But there's a shadowy side to it that I think is in many ways the most interesting and maybe the most promising long-term, which I suppose grows out of, one of Gandhi's fundamental insights, which is sometimes you do things that make the oppressor show its claws. So what happened in Philly when we tried to massively reduce the enormous caseload of probationers and parolees is that we got all of this resistance we were not expecting coming from probation and parole. The caseloads, after all, were way too big. Where was it coming from? Well, it was coming from patronage. It was coming from the reality that there were 300 probation and parole officers in a city with 300 prosecutors. And we heard at a meeting, some of the people from probation and parole grumbling about the DA's office saying they are, quote, taking our bodies, unquote. Man, if that ain't showing your claws with a history of slavery, to say that the reduction of probation and parole is taking your bodies, well, look at this. What do they mean by taking your bodies? They actually mean a couple of things. And one of the things that they mean is that this is an on-ramp back to mass incarceration. And there were major statewide reductions in the populations of state prisons. Philly has no state prisons. So all the Philadelphians you lock up, which is about 1/4 of the statewide population, become a cash cow for other counties, many of them conservative counties, Republican counties, Trump counties, where steel is gone and coal is gone, but damned if they don't have a business and black people in their jails, okay? That is definitely showing your claws. And it also was simply an issue of patronage. The way that you got to be a probation officer, parole officer, in some instances in Philly was knowing the right people. But when you reduce the caseload, their fear, right or wrong, and it was mostly wrong, was you'd reduce the number of probation and parole officers, it would reduce the power of their supervisors, et cetera. What we started unwittingly was a war, but it was a war for the hearts and minds of what it is we actually want to do as a society with criminal justice and with our resources. And that, to me, even though it's shadowy and nasty and kind of awful, in the same way a lot of these state correctional officers associations going after George Gascon or going after Chesa Boudin is nasty. What it is about is it's forcing us all to face the issue. And the issue is, among other things, that there is a commerce in putting human beings in cages. And when it is not necessary, and when it is not appropriate, and there is another kind of cage, and that cage is electronic, or that cage is supervisory, when it's not necessary or appropriate, then this really is nothing more than a watered down version of something like slavery.
Thank you for that. Okay, so we're a few minutes late for the question and answers, and I want to get to those. That there are. I'm just looking at some of the questions, and really they're all fabulous. On any one, we could spend a good amount of time. But let me pick one that's sort of broad, and I think each of you will have something to say on it. And maybe I can start with Fiona to start us off. It's from Dylan, who asked, from a policy perspective, why is anyone ever revoked from supervision to incarceration? Why not use non-carceral sanctions for less serious violations and suspend supervision indefinitely for new crime violations that would have their own criminal prosecution process, after which supervision could be resumed?
So I think part of it is, picking up on some of the, like the criminal justice system does punishment really well and does things like incentives less well. So it's partly the machinery and just what people are used to. But I also think that we really need to build up true alternatives that have public support, and that these alternatives can't just then become added conditions of probation. And the way to deal with criminal violations is to reduce, make the standards beyond a reasonable doubt. Again, I think that's the best way to handle those.
So Vinny, let me ask you to take a shot at this, since you created this organization called Exit, of which I'm a part, Executives Transforming Probation and Parole. And I know you and your colleagues have spent a lot of time thinking about these issues broadly and specifically, but what about this notion of why ever use any kind of carceral sentence for a technical violation? And part of the import of that question is that it raises, and why would you ever use the technical violation process as a way to handle a new case? But why don't you take this for a minute? Sure.
And Exit, I'm glad you mentioned it, because I would have gotten in trouble with my Exit colleagues had one of us not mentioned it. So thank you for doing that. And it's over 100 probation and parole commissioners. There's I think over 50 district attorneys, defense attorneys, formerly incarcerated people, victims, who have signed on to a call to reduce mass supervision, to incentivize people with early discharge, as has been mentioned, and very importantly, to stop revoking people for technical violations, to just not do it anymore. And I think that, I can imagine this debate playing itself out with the worst possible technical violator who everybody hates, and that's going to be the icon for why we should keep technical violations. But I think that the potential for abuse and the realization of the potential for abuse far outweighs any benefits we've been getting from technical violations. There is, let me say this as clearly as I can, there's no evidence that these technical violations improve public safety, and plenty of evidence that they are meted out in a racially disparate fashion, cost billions of dollars, and really warp the relationship between people who need help and people who are ostensibly hired to help them. So if we could eliminate that from the equation, and we could just train our POs to do the kinds of things that Larry and Eric just talked about, to kind of help people turn their lives around, help them get apartments, help them find a job, get mental health and drug treatment, the kinds of things that they were originally set up to do in the 1800s, we would be in way better shape. And that's essentially what exit and hundreds of, law enforcement, legal and correctional officials have said should happen.
Thank you, Vinny. That seems like a perfectly appropriate and excellent sort of final statement to sort of wrap this up. And as much as I hate to give you the last word on a panel, it looks like you've had it. We've hit our time, and we want to be respectful of everyone's time here, the panelists and the audience. A special thanks, obviously, to all the panelists who did this and took their time to do this. I think it was a great conversation. We could have all spent hours talking about this, but thank you so much for doing this, and we look forward in a variety of ways to continue this conversation. Thank you all.